Hi, everyone. Welcome in. Thanks for joining us. My name is Carrie. Oh, and spoiler alert today's topic, the Darrell Brooks trial. So I put together something for you all, my take on the trial in 5-minute segments. So here's part one. Enjoy.
Mr. Brooks, stop talking.
Objection, hearsay.
You would like to, you're asking that to voluntarily be taken to that courtroom.
All right, why don't we print that off so that Mr. Brooks can review that as well.
And to being called that name, what do I need to be reviewing?
Can I come back? Can I come back?
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings.
With all due respect,
Still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
Let you bias you pretty good at me here. Don't even tell the jury the truth.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you keep changing the jurisdiction. Jurisdiction, it's a subject matter jurisdiction that has yet to be proven on the record. So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
And I object to that. I have yet to prove subject matter jurisdiction.
You're being tainted this and that, Mr. Brooks. Don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit degrees, being writers, judicial misconduct, trying to steal somebody's session.
One last time, Mr. Brooks, do you have a position?
Can I go over the document, please? Can I do that, Your Honor? Respectfully for the record, may I do that?
Can I at least raise the issue of subject matter jurisdiction? That's not
There's no lawful motion before the court. You may not.
A reference to the charges in this matter. Paperwork that would state the charges. Any paperwork.
I just want to be treated fairly, which I have not been.
So can we adjust the subject matter jurisdiction?
No, we cannot.
Talk about that.
Your Honor, as a public servant, I have the right to ask questions
Sir?
of Your Honor.
Are you aware of who the plaintiff is in this matter?
Jacksonville House. We're talking about constitutional rights.
Are you aware that the state of Wisconsin is an entity and cannot claim to be an injured party in this matter? Grounds.
It's 906-11.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand?
Objection. Hearsay.
It's not hearsay.
That's my decision, sir.
Are you making a judicial determination that those have no merit?
Sir Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for a finding of fact.
Your request is denied.
Objection. What was the answer to the last question?
So this is your final warning, or you will be removed to the other courtroom.
Objection. Being a witness.
He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask.
In any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do.
I'm simply trying to have a fair trial. Will Your Honor honor my First Amendment right? Are you making the are you taking
As
it?
I've already addressed.
You're making a judicial determination to deprive me of my constitution.
I am not making any such determinations.
So you just said you're not going to answer the question about my First Amendment right.
Sir, I've already answered the question that you have a right to present a defense. You have a right to present your defense, but your rights are not unfettered.
Objection. Hearsay.
Overruled.
The record will reflect that Mr. Brooks did not give consent. Mr. Brooks, any topic or under 90611, I will close the cross-examination.
The Darrell Brooks trial, the trial that never ends, the trial that we can't seem to get enough of. And why can we not get enough of it? Well, this is why.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
Okay,
So
these admitted into evidence.
For the record, I didn't bring up the word fire lady.
continue then. We're going to move on, Mr. Brooks. Let us continue with the
We gonna move on to subject matter jurisdiction that has yet to be proven.
Detective Carpenter. You can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought in.
So we're not gonna address that at all. That's not gonna be proven for the record. Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
Continue to interrupt. You risk forfeiting your right to be present in this courtroom.
Your Honor, may I see a sworn affidavit of the nature and authority of the court? Grounds. Hope the record reflects that.
Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern.
I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then are you aware of who the plaintiff is in this matter?
Objection relevant.
Grounds. You're not going to address that either. That's still not going to be proven, right?
And did you notice anything different about your surroundings as you heard the screaming?
Objection. That's the form of that question and it was answered.
Overruled, he may answer.
Can you just repeat the question, please?
Sure. Do you notice anything other than the screaming that seemed unusual when that happened?
Objection, different question.
Overruled. Not sure what the objection is, but you may answer.
Can you just repeat the question, please?
That's Mr. Brooks. I cannot explain to you if you don't understand the basis and law for the denial.
I'll understand.
I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom?
I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Record should reflect he's holding up his objection sign. It appears that he's writing I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements? That's not how it was said.
That was how I said. You want to run the record back?
And you're
Nice stuff.
through.
But I see through it.
So
With all due respect, Your Honor, every
Mr.
time we...
by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
Can the title man please direct the prosecutor to answer whether their assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay?
Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven?
I'm tired of being in the courtroom that has no integrity whatsoever.
That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case, as your own
To represent myself pro per. At that time,
Were you provided the complaint in this issue?
I'd agree to it. It's stopping it.
to reflect.
The reason for bringing it up was to make sure that they are offered into evidence.
So we're not at the evidentiary phase. They're part of the record. They've been received.
So I'm not hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach?
You're assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
Hey, I don't consent to this. First of all, I accept for value in return for value this paperwork. Don't I have rights though, Your Honor? I don't understand anything, and I accept for value in return for value this document.
The information and all documents in this case, your objection is noted. It does not need to be repeated. Mr. Brooks,
I have a right to be present for trial.
Are you aware that I don't identify by their name?
Okay, so here's the deal. I got this one video that I thought that you guys would appreciate that we're going to kick off the night with.
Madam Clerk is pulling it through, and I will provide the parties with a written copy here in court. It addresses the matter of subject matter jurisdiction.
So we're going to address it?
No, I've issued an order. I'm going to give it to you. That's why I'm addressing it. You can review it later, but there's a written decision now denying your motion to dismiss.
So is that including verified proof that you have subject matter jurisdiction? Because it has yet to be verified or proven.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get a written decision. That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
I accept for value in return for value this document.
That I have not received.
Thank you for noting that. All right, bring the jury out. State has its next witness, I presume, ready to go? All right. When the jury's brought out, you may call the witness.
Is that verified proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe so.
Unequivocally.
There's no verified proof proven yet.
Yeah, it's the same.
There's no verified proof if we're in common law or admiralty law. What court is this?
Sir, I believe your answers will be in that decision and order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay.
I accept it for value in return for value, so.
All right, they're in there, sir. It's a final order for
Verified
purposes
proof
of
is in
appeal.
there? Verified proof
So
is in
if
there?
you'd like to challenge that, you can take that up with the appellate courts.
Verified proof is in there?
All right.
Because I don't think it is. Proof of claim is not in there either. No one has a claim.
Oh, Darrell. Yes, if you guys don't mind, hit that like button down below. Okay, sorry. Just had to get that one out of my system. Do you guys think he put those boxes right there so that he could hide stuff from the prosecution? Like he thought he was being slick. You know, he always had that thing. They tried to be slick.
We'll call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Walker, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second.
I forgot my script.
Everything since they just kind of late today.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, I do want to put on the record, I gave the parties this morning, it's an excerpt from a judicial bench book on opening statements. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the record, is this the which you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I
wasn't going to
preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that.
Okay, great.
I wanted to make the record clear. So I appreciate you indicating to me that you're aware of that.
However,
even though subject matter jurisdiction has not been proven on the record and should be addressed.
Does not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be proven on the record. I'm not going to go down this path today. I'm just advising you, you cannot reference that in your opening statement. That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed
proven
a
for the record
motion.
by the prosecution.
Objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go ahead. You can make.
I didn't look at the document. I accept the return, accept for value, return for value, the document. I didn't look at it. So I don't know what I'm supposed to say to that.
This video right here drove me absolutely insane. Let's watch it together.
Welcome back, Mr. Brooks. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you, I would like you back here. It's always my preference that you're here. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask
filings.
me questions, I'm going to mute him. Motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to back to this courtroom, and he chose not to answer it, but instead he's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask, and I just wanted to make a record of that.
I'd like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not. All right, why don't we print that off so that Mr. Brooks can review that as well.
Consent to being called that name. And what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote unquote jury view?
Yes.
I accept for value in return for value this document. Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document that was
Reference to
accepted for value and
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848, and the defendant, Darrell Brooks, appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this
I
morning.
just wanted it stated for the record that I
Mr.
do not
Brooks,
identify by the
it
name
wasn't
that
the
you called me
proper
by. That's
time
all.
to do that. That's now the third interruption. So,
With all due respect, Your Honor, every
Mr.
time
Brooks,
we, every
by
time
saying
we,
all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I
my
have
right
a number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is
morning.
my right to,
Mr. Brooks, you do not have a right to interrupt the court.
no, it was,
I will
that
remind
was
you
not
once
my
again.
intention.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.